Welcome to lecture number 2. In this lecture, I'm going to give you an overview of the U.S. court system, and that's going to be the federal court system and actually our local statewide court system as well. A note, for the bulk of the class, what I'm talking about is going to be based, when I talk about local stuff, it's going to be California based because this is California Community College, and this is the court system that's going to impact most of you. I recognize that people take this class from all over. Just know that if you're not in California, or sometimes even if you're not in San Diego, your local system may be a little bit different, and I will try to get to those nuances when I can. Okay, so your learning objectives for this lecture, we're basically just going to give you an overview of the U.S. court system, the 3 branches of government, and state and federal courts. So we have, as I mentioned in the last lecture, 3 branches of government: the legislative branch, the executive branch, and the judiciary branch. The judiciary branch is the branch of government that addresses the federal court system. And when we look at the federal court system, I'm just going to really quickly zoom in here because I cannot see this. I can't see anything really. Ooh, I'm going to make that brighter for you guys. And so when we look at the checks and balances, and you've got this great graphic here, but I'm just going to talk about it from my perspective. So Congress makes the law. So they actually draft the statutes. They draft statutes, but those statutes have to be signed by the president. If the president doesn't like the statute that Congress creates, that president can veto the statute. That veto can be overridden with a 2/3 vote of Congress. That goes back to your high school civics class, but just a little refresher. The executive branch, though the president also can propose legislation, but it has to be taken up in Congress. So the president can say that they have this great idea, but if Congress doesn't do anything about it, that idea goes nowhere. The judicial branch can take a look at the law that was created by Congress and signed by the president, and they can declare that law unconstitutional. They also have the power to hear cases that might not necessarily be based on constitutional law, but they might declare that a federal statute is not valid. And the check on their power is that if there is an unpopular legal decision, the legislative branch can create a law that negates that unpopular legal decision. I'll get more into that in maybe a few minutes. This whole idea that power is shared between the 3 branches is referred to as federalism. Some power goes to the federal government through the Constitution. Power that is not, and that power that is granted to the federal government is limited to those branches of government that have the ability to control that thing, for lack of a better word. And I'll talk more about that when I get to the Constitution. But power that is not specifically granted to the federal government is retained by the states or the people. Okay? There are some things, like your freedom of speech, that the government doesn't have the power to control ever, with the caveat. Time, place, and manner, I will talk about that when we talk about the Constitution. So moving on to the court system. In order for a court to hear a case, they have to have jurisdiction. And jurisdiction basically means that the courts have authority to hear specific types of cases within their jurisdiction. So for example, small claims courts. Small claims cases are cases in California, civil cases of less than $12,000 in dispute. Those cases go to the small claims court. Family courts have jurisdiction over the dissolution of marriage or divorce and child custody. Probate is the selling of the estates or settling the estates of deceased persons. A family court judge cannot make probate-based decisions. A small claims judge cannot make decisions that would be related to family court. So you can't sue your ex-spouse, or you can't sue your spouse for child support in a small claims venue. You have to go to family court for that, because that is where those types of cases are allowed to be heard. At the lowest level, when you have a legal dispute with somebody, you go to the trial court, whether it's a state trial court or a federal trial court. That is the court that is tasked with determining the facts of a dispute. Their job is to find out what happened and to apply the law. So when we look at who has jurisdiction over certain types of cases, typically civil cases are heard at the local state trial court. Locally, we refer to that as the Superior Court. Closest Superior Courthouse to Oceanside is in Vista. By the way, the Superior Court in Vista has many jurisdictions within that courthouse. There is a family court, there is a criminal court, there is a civil court. So all of that is at the Vista Courthouse. At the next level, we have the state appellate courts. And what the appellate courts do is they accept the facts given by the trial courts, and their job is to look for errors of law. And then at the highest level in the state, we have the state Supreme Court. This is the highest court in the state, and they accept some appeals from appellate courts, but a very small percentage. So generally, when you have a court case, at most, the highest level it typically goes to might be the state appellate court. Very, very rarely do cases go to a Supreme Court. At the federal level, we have the federal trial court, which our closest federal courthouse is in downtown San Diego. At the appellate level, we have the federal appellate court. There are 13 circuit courts across the United States. California is in the 9th district. And we also have U.S. specialty courts. Bankruptcy is a U.S. specialty court. Anytime you file bankruptcy, it's federal, and it goes to a bankruptcy court, which is a U.S. special jurisdiction. Taking a closer look at the federal courts. So federal trial courts, closest one, San Diego, are tasked with federal questions and diversity jurisdiction. Federal questions, claims based on the U.S. Constitution. I am a prisoner in a penitentiary in Kansas, and I feel like the penitentiary has violated my civil rights. That's a federal question. A federal claims based on a federal statute, so federal law, or a federal treaty. Federal trial courts also have what's called diversity jurisdiction. Diversity jurisdiction takes place when the plaintiff and the defendant are from different states and the claim is $75,000 or more. So I have a dispute with somebody who lives in Nevada, and the claim is for $125,000. That is a federal case, if I want it to be. The thing with diversity is that I can choose to have the case heard in federal court, or I can choose to have the case heard in state court. Why would I want to have it heard in state court? Why would I want to have it heard in federal court? Well, the person in Nevada might think that it should be heard in federal court because that way there's no bias from a California judge for the California plaintiff. However, maybe having the case heard in federal court takes more time. Maybe it costs more money because finding attorneys who argue in federal court might be more difficult. And so maybe plaintiff and defendant might decide, well, even though it can be diversity, I don't necessarily want it to be diversity. And maybe we both agree to have the case heard in California, or we agree to have the case heard in Nevada. In a contracts case, the contract is always going to tell you, if the contract was written well, where disputes will be heard, what court has jurisdiction. Federal appellate courts, again, they accept the facts that are given by trial court. They look for errors of law, and then they also hear state death penalty appeals. Anytime a state applies the death penalty, there is always an automatic appeal granted. That automatic appeal will always go to the federal appellate court. And then we have the U.S. specialty courts, again, bankruptcy, tax court, military court, all of that stuff is federal. And we also have the U.S. Supreme Court. So when you have your case heard at the trial court level and you lose, in most cases, you have an automatic right of appeal. There are certain times when you don't. For example, small claims cases, you don't have an automatic right of appeal of a small claims case. But a civil contracts case, you always have the right, if you are the losing party, to appeal the decision. The appellate court looks for errors of law, mistakes, and they make decisions based on those errors. They don't hear any more new testimony. They simply look at the court record. And then the U.S. Supreme Court is created by Article 3 of the Constitution, or was created by Article 3 of the Constitution. There are 8 associate justices and 1 chief justice. I say currently 9 justices on there because there's always some talk of increasing the size of the court. The court has not always been 9 justices. I think at one time it was 5, then it was 7, now it's 9. Who knows what it'll be in 10 years. Typically at the Supreme Court level, there are 5,000 to 7,000 cases filed yearly. The court gets to decide which one it wants to hear. They generally hear about 80 oral arguments each term. And they hear cases that they typically want to hear cases that answer important constitutional questions, issues of federal law, civil rights and liberties, and then cases of criminal law. In order to have your case heard at the Supreme Court, you have to file what's called a writ of certiorari. Say that 3 times fast. Certiorari. And that is the appeal by your attorney to, hey, Supreme Court, please, or the appeal from your attorney that says basically, hey, Supreme Court, we've got a really interesting case that you might want to hear. And you hope that your case is one of those 80 arguments that they hear each year. Generally, the Supreme Court starts the first Monday in October. They hear cases through about like January, and then decisions start to be released in the spring, early summer. So generally by the end of June, all of those decisions get published. And so when the court hears something in the fall, you generally don't know right away what the decision is going to be. You have to wait until the following spring. So Supreme Court also has its own special jurisdiction. The Supreme Court has original jurisdiction with suits between 2 or more states. So one state is suing another state. It doesn't make sense to do it in federal court. It makes sense to do it in the Supreme Court. Cases involving ambassadors or other public ministers, appeals of cases involving the U.S. Constitution, cases involving federal admiralty law or U.S. treaties, and cases where the United States is a named party. So someone is suing the United States or the United States is suing someone else. That is where, and the United States government, I should say. And those cases are typically heard at the Supreme Court level. The Supreme Court also has appellate jurisdiction for all federal circuit courts, the U.S. Court of Appeals for the Armed Forces, and state courts of last resort or federal constitutional issues or statutory law. And finally, someone who has been sentenced to death, they have appellate jurisdiction over any U.S. death penalty case. So that is kind of the overview of the legal system. I'm going to talk more about like what happens in a lawsuit in the next lecture, or maybe the lecture after that. I can't remember when, so look forward to that. But again, end of the lecture, what'd you learn? What will you take away beyond the lecture? Again, think beyond the topic and what can you apply to your life? I bet you may not have known that the local federal court is in San Diego and not in Vista. Maybe you didn't even know the local court was in Vista. I don't know. You tell me.